Court calls case of the people versus.
Before a single ruling is handed down, this courtroom is already sitting on a powder keg. What you're about to watch isn't just a routine probation violation docket. It's a collision between personal tragedy, legal obligations, and the cold mechanics of the justice system. On one side, the court is dealing with missed payments, failed reporting, and unmet program requirements. On the other, you're going to hear raw explanations involving loss, grief, homelessness, and survival. Judge Simpson runs a tight courtroom, and probation violations are one of the few areas where sympathy has strict limits. Today's cases revolve around a question courts face every single day. At what point do explanations stop mattering and accountability take over? You'll hear defendants explain why they fell behind, children to care for, deaths that shattered routines, systems that didn't call back. But you'll also hear the judge repeatedly return to one unmovable point. Probation is not optional. Conditions are not suggestions. As these cases unfold, pay attention to how the court weighs intent versus outcome. Does effort count if there's no proof? Does hardship excuse non-compliance? And when probation terms are maxed out, what options does a judge really have left? These moments escalate quickly, and by the end, lives change in real time.
Thank Martin.
Johnny.
Okay. No, I did that the last time. You were much nicer about correcting me this time, but come on.
Good.
That it nice this time. The last time it was like I had insulted her whole family. Anyway, go ahead.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Martin. Ms. Martin, please state your name again.
Johnny Martin.
Chris Moyer on behalf of probation. Your Honor, Ms. Martin is before the court for a violation of probation hearing. Ms. Martin has been on probation for 2 years for a reduced charge of assault and battery. In this case, Your Honor, Ms. Martin has made no payments to the court. Her balance is $1,530. Probation has failed to receive completion of the CPS Family First Program and Parenting class. Ms. Martin also failed to report to probation after April of 2024. And Your Honor, her probation term is maxed in this case. Given that these items were not completed, probation is recommending that Ms. Martin serve 93 days in jail with credit for 1 day served, that she served the balance.
This is where the tone of the hearing hardens. A 93-day jail recommendation isn't symbolic. It's the system signaling that patience has run out. From a legal standpoint, probation officers aren't looking at intent or emotion first. They're looking at compliance, no payments, no reporting, no verified completion of required programs. On paper, that's a clean checklist of violations. What's important here is the phrase probation term is maxed. Once a probation term hits its limit, a judge loses flexibility. They can't extend supervision. They can't keep warning. The remaining tool is jail time. That's not about punishment alone. It's about closing the case within the law. But this is also where viewers should ask themselves, if someone believes they completed a program but can't prove it, should the system pause or proceed? Bureaucracy doesn't show mercy by default. Proof is currency in court, and without documentation, even truth can look like an excuse. This recommendation sets the stakes for everything that follows.
Waive remaining terms, accept the financial obligations, and discharge her from probation.
Ms. Perry.
Your Honor, I was able to speak with Ms. Martin about these issues. She believes that she did complete the CPS and parenting class. She's been trying to get in touch with them for the last week or so to get proof of that. She has called the case manager that was on the case. She no longer works there. She gave her another number at CPS. They told her they would call her back. It's kind of been, she's been, thwarted by bureaucracy. So I'm asking to adjourn this hearing out a bit so she can continue working on that. Again, she remembers completing it, but it has
Why
been...
didn't that information get to probation?
Frankly, Your Honor,
I can tell you why, because she never reported to probation.
She did. And that is the allegation, Your Honor. Around the time that this was all happening, the father of her 2 youngest children was killed in Washtenaw County. And I think she's a single mother.
Emotionally, this is the most human moment of the hearing. The defense isn't denying the violations, they're explaining how life collapsed around them. A sudden death, 5 children, no childcare, no stability. This isn't a legal defense, but it is context. Here's the hard truth. Courts acknowledge tragedy, but they don't automatically excuse noncompliance. Judge Simpson listens, but notice how he doesn't interrupt probation's facts. That's deliberate. Sympathy can coexist with consequences, but it cannot erase obligations retroactively. This raises an uncomfortable but necessary question for the audience. Should courts build more flexibility into probation when major life events occur? Or does that undermine accountability entirely? The system assumes adults will communicate, report, and document even during hardship. When that breaks down, the law doesn't pause. It advances. And right now, Ms. Martin is standing directly in that gap between human suffering and procedural enforcement.
That kind of, greatly affected her life, and she's been dealing with the repercussions of that since that happened in June of 2023. So she wants to get proof to probation. She's just having trouble doing so.
What about payment? I have no payment. I have no reporting to probation. I have nothing.
I just started working out.
She has 5 children?
Yes.
5 children, 11, 8.
11, 9, 8, 3, and 1.
So she, for a long time, didn't have childcare to care for her children and work.
I just started working. I can't make a payment when I get my check. It's
How come you
hard.
didn't report to probation?
I don't know. Like I had after my child's father passed away in my apartment complex, I just shut down. It was like real hard on me.
I get all that, but I guess the last time you were before the court was in February. You're going to pay the fines and costs by March 3rd. No payments. You would report to probation. No reporting to probation. I'm assuming you were supposed to complete the Family First program and parenting classes. I don't have any proof of any of that.
As I completed it, I went to Orchard's Family Children and Family Services. I think that's what it's called.
When?
I finished that class in 2023. I just didn't report it.
So you're saying that was completed before I sentenced you?
Yes.
Or I can try to look to see what the prosecutor's office may have.
What the prosecutor's office may have?
Yeah, I mean, maybe it was provided to them to reduce the charge, as this charge did originate as a child.
Anything else from anybody?
Nothing from me, Your Honor.
Do you have anything else you want to tell the court?
I was just give me some time to make the payments. I'm all my kids got. I don't really want to go to jail. I'm all they have.
Should have been keeping in track with probation.
Right.
You just didn't do anything.
I know that I did. I know I did.
Okay, so here's what I'm going to do. I'm going to waive the remaining terms except for financial obligations. I'll discharge her from probation without improvement. What I am going to order is that she's to serve 93 days in jail. I'll give her credit for the 1 day. She's to serve the balance. I will strongly consider release if I get proof of completion of that class.
This ruling is more nuanced than it sounds. Yes, Ms. Martin is remanded, but Judge Simpson leaves the door cracked open. not with promises, but with conditions. Proof is the key. If documentation of completed classes appears, early release becomes a possibility, not a guarantee. Legally, this is the court protecting itself. The judge enforces consequences while still allowing relief if compliance can be verified. It's accountability with a pressure valve. Notice something critical. The financial obligations remain. Jail doesn't erase debt. Probation doesn't cancel fines. Court costs follow defendants long after the hearing ends. Here's a question worth asking. Should proof obtained late still carry weight, or does timing matter as much as completion? The judge clearly believes timing matters, but he's willing to look. This moment shows the balance courts try to strike. Firmness without cruelty, structure without total rigidity. Whether that balance feels fair depends entirely on where you're standing.
All right, you're still going to owe the money. You need to set something up with the court. You're going today, but if they get me proof of that, then I'll consider release. I'm not guaranteeing that I'll release you, but at least I could have something to look at that says you did something.
Okay, can I at least can we call the people?
Call which people?
For the,
You can talk to your attorney. We can figure out a way to make the call, but right now you're going. Defendant's remanded. Court calls the case People versus Chance Stallings.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stallings, who stands to my right. Please state your name for the record, sir.
My name is Chance Stallings. Good morning, Your Honor.
Teresa Claire on behalf of probation. Your Honor, Mr. Stallings is before the court for a violation of probation.
You take your hands out of your pockets. Go ahead.
Mr. Stallings is non-compliant with the terms ordered by this court in that he owes a balance of $1,725. His last payment to this court was made in January of 2024. He failed to provide proof of substance abuse treatment. He failed to provide ongoing proof of mental health treatment. Mr. Stallings, to update the court, did provide me with some documentation, but that was dated in 23. So it's nothing that is updated or a status report that anything continued. He failed to report to probation as directed. He would contact me sporadically throughout the term, but nothing consistent like he was supposed to. Mr. Stallings also has a new pending criminal case of domestic violence and an assault out of Toledo. That alleged date of offense was February 20th of 2024. He failed to appear on that case and is in bench warrant status there.
The second case escalates the tension immediately. Unlike the first, this one carries a shadow charge, a pending domestic violence case with a bench warrant. Even though it's technically just an allegation, courts treat new criminal conduct during probation as a serious breach of trust. From a legal standpoint, probation is conditional freedom. When a new case appears, especially one involving violence, the court's tolerance shrinks fast. Add inconsistent reporting and unpaid balances, and the outcome narrows dramatically. This is where viewers should consider, should allegations alone influence sentencing when probation violations already exist? The judge isn't ruling on guilt here, but risk matters. Probation officers aren't weighing innocence, they're weighing compliance and public safety. And when those two intersect, judges often default to confinement as the safest legal option.
He has matched the 2-year term in this case. Given all the violations before this court on this matter, probation is recommending that Mr. Stallings be remanded to serve 365 days in jail with credit for 77 days served, that he serve the remaining balance, that he complete the in-jail Dawn Farm program, waive remaining terms, accept his financial obligations, and discharge him from probation without improvements.
Response.
Thank you, Your Honor. I have had, of course, the opportunity to review the allegations as well as the recommendation and discuss them with Mr. Stallings. I guess I will just address each one by one. We do acknowledge that there is that balance owing. My client states that he could make the payment in full today. We do also acknowledge that the substance abuse treatment was not completed. However, my client does state to me that he has been on his own attending NA meetings and that he is on a waiting list through his insurance for the mental health to get into the substance abuse treatment program. He relays to me that he's been on a waiting list for almost 2 years. He did provide that documentation from 2023 that Ms. Polero referred to. We do acknowledge that the reporting has been sporadic. Mr. Stallings states to me that during his time on probation, he experienced homelessness for quite some time. So he often didn't have access to a phone, or he didn't have an ID to be able to go to the library and use their computer to try to do the online monthly reports. He does acknowledge, and there's no arguing that, yes, his reporting was very, very sporadic. And he does acknowledge that a lot of it was because of his housing insecurity and homelessness. He does also acknowledge that there is that new case. As of right now, they are just allegations, and he does believe that he will be found not guilty upon the resolution of that case. Ultimately, we're asking that the court, when I do also want to mention, my client also suffers from narcolepsy, and he has been applying and trying to get SSI.
This defense argument is layered and strategic. Homelessness disrupts reporting. Medical conditions complicate employment. The attorney isn't denying failures. She's reframing them as systemic barriers rather than willful neglect. Legally, though, probation conditions don't adjust automatically for life instability. Courts expect defendants to notify, document, and request modifications. Without that paper trail, explanations land softer than evidence. Here's the engagement question for you. Should probation systems proactively adapt for homelessness and medical issues, or does responsibility still rest solely on the individual? Judge Simpson listens carefully, but his response later shows a pattern we've seen all docket. Once probation is maxed and violations are established, discretion collapses. The law doesn't ask why forever. Eventually, it asks what now.
We are asking that the court, because we do acknowledge that the probation term here is maxed. I'm asking the court to discharge him from probation without improvement, waive the remaining terms outside of the financial, which he states he could pay the balance in full today, and not impose the jail time, given the fact that he has dealt with some serious housing insecurity and does have a health issue. And in the alternate, if the court was to impose the jail time, I would ask if the court would consider early release upon the completion of that in jail Don Farm program. Outside of that, Your Honor, that would be my request.
Anything you want to say, Mr. Stallings?
Your Honor, I had a pretty unbalanced last 2 years. The first year I was pretty decent with reporting and keeping updated with Ms. Polero. Once I fell into homelessness, I really fell off track. I've recently started improving again. I have a job I work at. I recently got a tax refund, which is why I'd be able today. Your Honor, the defendant in that case is present in the courtroom, and we're the one that's out of Toledo. We're working on getting it dropped. It's just a really tedious process with the clerk's offices out there. She's trying to contact the prosecutor to set up an account. As I said before, I'm just trying to be a better man for my kids, and I understand that I have and take accountability that I haven't been in full compliance with reporting. I've been doing the best that I can, Your Honor, and I'm at your mercy.
This is the emotional apex. When a defendant says they're at the court's mercy, it's an acknowledgement of lost leverage. Admissions matter, but timing matters more. Courts reward early compliance, not late realizations. Judge Simpson isn't dismissing the effort to improve, but improvement that arrives after repeated violations rarely outweighs the record itself. Accountability in court isn't about intention, it's about consistency. Ask yourself, if progress comes only when jail is imminent, should it still reduce consequences? This moment underscores a reality many defendants face. Personal growth doesn't always align with legal deadlines, and when they miss each other, the system chooses deadlines.
Well, there's not a lot else I can do. I will order that he, once remanded, is to complete the in jail Don Farm program. I'll consider maybe circumstances of his release at that point in time. I'm going to waive the remaining terms, accept the financial obligations, discharge him from probation without improvement. I am going to sentence the defendant to 365 days in jail, credit 77 days served. Defendant at this time is to serve the balance. Defendant is.
Both cases end where probation violations often do, with incarceration not as revenge, but as closure. Judge Simpson applied the same framework twice. Violations established, probation maxed, discretion limited. Personal hardship was heard, acknowledged, but ultimately outweighed by non-compliance. The broader implication is clear. Probation is opportunity, not leniency. Courts expect communication, documentation, and follow-through, especially when life gets difficult. Sympathy exists, but structure dominates. These rulings remind us that the justice system doesn't pause for chaos. It demands engagement even during hardship. And when that engagement fails, consequences follow swiftly. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.